Let's bring in Robert Patillo, a civil rights attorney, joining us now. Robert, always good to have you with us. Okay, so clearly, I don't think any brand would want to be affiliated with dog doo-doo. So I can see that side of it. But is this a case of copyright or rather trademark infringement?
It absolutely is the case of trademark infringement. I think that the district court's ruling will indeed be upheld by the Supreme Court because these brands spend hundreds of millions, if not billions of dollars to establish a brand image. They have established the branding, they put money into focus groups in order for people to have a certain association with their product when they see it, when they see the branding around it. Think about the McDonald's golden arches, the Coca-Cola logo, etc. So if you allow people to simply say, look, I'm stealing this and I'm going to use it to make money off of, but I just feel like I should get to use it because I'm making a joke at your expense, well, then that basically damages those brands and waste all the money those people are putting into trying to ensure that people have a positive image going forward. In this case, when you're taking the Jack Daniels image, something that's consumed by consumers, and you're putting poop jokes on it, well, then of course the brand is going to have a problem with that. And if this company really wanted to make a Jack Daniels themed product, there's a licensing process they can go through with the company to have an officially licensed product. They did not attempt to do so. They're simply trying to monetize the goodwill and brand equity of Jack Daniels.
But in terms of what's protected under the use of a parody, like, where's the line?
Well, the Supreme Court has established a very fuzzy line on these things. I think we're going to get more clarity here because on the one hand, you can say, well, yes, it's a parody, it's a joke. We don't want to outlaw humor in America. But at the same time, we're going to give you one of those good law school hypotheticals. Let's say that this dog toy went on to experience a massive recall because thousands of dogs were injured by it. And now people associate this defective product with Jack Daniels. Yes, it was a parody, but now you're having real market harm to Jack Daniels and their branding, which I'm a fan of Jack Daniels if they're watching. I'm a great fan of yours, please. But at the same time, I think people have to realize that the amount of money being poured into establishing a brand cannot simply be thrown away because somebody wants to make a parody or a joke about it when there can be real harm to consumer image of the product.
I want to read what the attorneys for Jack Daniels told justices in court papers. Really interesting. First of all, they said it gives copycats free license to prey on unsuspecting consumers and mark holders, and warned that if this decision wasn't reversed, companies could use trademarks they don't own to flood the markets with allegedly unserious products. Now, that sounds kind of funny. That sounds like something you might hear on Saturday Night Live, an unserious product. But this was, I think, a valid perspective. It says, no one disputes that VIP is trying to be funny, but alcohol and toys don't mix well. And the same is true for beverages and excrement, they wrote. This is in court papers. The next case could involve more troubling combinations: food and poison, cartoon characters and pornography, children's toys and illegal drugs. It almost sounds like they're stating the obvious here, but is this legally something they can stand on?
I think that it is, because since this is a judgment call, kind of that old case about what is the definition of pornography, I know it when I see it. In this situation, the Supreme Court has to kind of weigh the interest on both sides. On the one side, you want to give creativity to smaller companies, the ability to parody, as it was written in the filings by VIP Corporation, that you have to have it close enough for people to get the joke. And I think that's a line that people understand. But at the same time, you cannot allow someone in the interest of this to start associating dog excrement with my beverage that I want people to drink. There has to be a line drawn somewhere. I think that's what we're going to get from the Supreme Court in this case when the ruling comes down.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.